Hey everyone, and welcome. Have you ever thought about what separates a savvy entrepreneur from someone who, loses their house when a business venture goes south? The answer is this really powerful legal idea called the corporate veil. And today, we're going to find out just how strong that protection actually is. So let's just cut right to the chase. Here's the big question. If your company fails, do you lose your house? Are your personal savings, your car, everything you own on the line? The answer to that question is buried in this legal shield we're about to unpack, and honestly, it's one of the cornerstones of modern business. All right, here's our game plan for today. First up, we'll tackle the kind of weird idea that a company is a person. Then, we'll dive into the legendary case that built this whole concept. We'll look at the consequences, and then, the juicy part, we'll see when the courts are willing to tear it all down. Okay, Section 1, the company as a person. Now, if you want to understand how entrepreneurs can take massive risks without betting the farm, you got to get your head around this core concept. It's a bit of a strange one, but it's crucial. The law treats a company like its own person. And this is what lawyers call a separate legal entity. The best way to think about it is like you're building a legal robot. Seriously, once you register a company, you've created this entity that can own stuff, get into contracts, sue people, and get sued, all by itself. It has its own life, completely separate from you, the person who made it. So where did this wild idea even come from? Well, it wasn't just invented out of thin air. It was cemented in a huge legal showdown way back in the 1890s. This is the case that built the foundation, the one every law and business student has to know. We're talking about the Great Wall of Solomon. Okay, so here's the story. You've got this guy, Mr. Solomon. He has a successful leather business. He decides to turn it into a limited company. So he sells his business to his new company. In return, the company pays him with shares and, this is the key part, a secured loan. Now that loan basically put him at the front of the line to get his money back if things went wrong. And wouldn't you know it, the company failed. The other people the company owed money to were furious. They said, hey, this company is a sham. It's just him. He should have to pay us out of his own pocket. But the case went all the way to the top, to the House of Lords, and they came back with a bombshell ruling. They said, and I'm paraphrasing here, look, once a company is legally registered, it is a different person altogether, full stop. They made it crystal clear that even if one guy owns all the shares and runs the whole show, the company is not his agent. Its debts are its own. And just like that, the Great Wall was built. All right, so a company is its own person. What does that actually mean for the people who own it? Well, it leads to the single most important consequence of this whole idea, the power of limited liability. This is the answer to our opening question. Limited liability is exactly what it sounds like. Your liability, your risk, is limited. As a shareholder, your personal stuff is protected. If the company racks up millions in debt and goes bankrupt, the most you can possibly lose is whatever you paid for your shares. Your house is safe, your savings are safe, and you can see why this is so huge, right? It's what gives people the confidence to invest and start businesses. And believe me, the courts take this separation incredibly seriously. I mean, look at these two cases. In one, a guy named Makawara owned a forest through his company. He tried to insure the trees in his own name. When they burned down, the insurance company said, nope. The trees belonged to the company, not him, even though he owned the whole company. And in another crazy case, a guy was the owner, director, and main employee of his own crop dusting company. When he tragically died in a crash, the court said his widow could get workers' compensation because he was an employee of his separate company. The separation is that absolute. Okay, but what happens when people start to abuse this? When this amazing shield is used as a weapon for fraud? Well, that brings us to the big exception to the rule. This is when we talk about lifting the corporate veil. And this really gets to the heart of the matter. You've got this constant tension in the law. On one side, you have the rule from Solomon, which gives businesses certainty and encourages people to take risks. But on the other side, you have the exception, lifting the veil, which is there to stop people from using the company structure as a get-out-of-jail-free card for fraud. It's a real balancing act. So let's get into the specifics. When exactly will a court peek behind the curtain? Well, it happens in two main ways. Sometimes, there's a specific law passed by Parliament that says they can. Other times, judges will do it themselves when they see someone is clearly up to no good. Okay, so let's look at the statutory examples first. You've got two big ones here, fraudulent trading and wrongful trading. Fraudulent trading is exactly what it sounds like. It's trading with the intent to defraud people.
It requires real, provable dishonesty, so it's pretty hard to pin on someone. Wrongful trading is different. You don't have to be a crook. This applies to directors who keep trading when they know or should have known the company was doomed to fail. It's about being negligent, not necessarily malicious.
And then you have the classic cases where judges step in. These are the textbook examples of abuse. In one, a guy named Horn left his job and was under a non-compete agreement. To get around it, he set up a new company in his wife's name to carry on the business. The court saw right through it, calling the company a mere facade. Then there's the Lipman case. A guy agreed to sell his house, changed his mind, and quickly transferred the house to a company he controlled to block the sale. Again, the court wasn't having it. They called the company a sham and a device and forced the sale. So with these examples, you might think courts are lifting the veil all the time, but you'd be wrong. In fact, the modern approach is the complete opposite. The courts have become much, much stricter about when they're willing to do it. And the case that really slammed the door shut was Adams v. Cape Industries. This was a huge one. The court basically said, we are not going to lift the veil just because it seems like the just or fair thing to do. They rejected all these fuzzy arguments. They boiled it down to one very specific situation. The only time you can lift the veil is when a company is being used as a facade to evade a legal obligation that the person already has. The Supreme Court later refined this even more, giving us two key ideas. First, the evasion principle. This is the only time the veil can actually be pierced. This is when you're using a company to get out of a legal obligation you already had. But then there's the concealment principle. This is when you're just using a company to hide what you're doing. In that case, the court said, we don't need to pierce the veil. We can just look through it to see the reality of the situation. Which brings us all the way back to where we started. After all that, is the corporate veil easily torn? How strong is this protection, really? And the answer today is a very clear no, absolutely not. While the courts will step in to stop outright fraud, the core principle from the Salomon case is stronger than it has ever been. So in the end, it's best not to think of it as a veil of fabric at all. It's much more accurate to call it what it is, a wall of steel.